Now, in addition to ignoring disputes over witnesses, Jack Smith's brief is full of incoherently vague hedging that suggests that they still do not know.
So I think it is logical that some acts are immune. The core constitutional responsibilities of any president, put Mr. Trump aside, ought to be immune from prosecution.
The lower courts, again, will have to hear it. It will, in my opinion, slow down Jack Smith's persecution and selective prosecution of President Trump. And I don't see how this case could go forward before the election.
Government prosecutors destroyed Trump's evidence, and it's important evidence, exculpatory materials that tend to show that Trump is innocent. Now he cannot make those arguments. So what do? We ask for sanctions. What is one of those sanctions? A dismissal of the case. Trump submitted this motion to dismiss and a reply to Jack Smith's response that we'll read through here. And Trump's team went hard on this one. Let me show you what's going on out of Florida. And it comes in the Southern District of Florida. We know this is Judge Alina Habba presiding over this case. Says President Donald Trump, this is Trump writing, now replies in support of a motion to dismiss the classified documents case because Jack Smith destroyed evidence. Trump says, all right, Judge Cannon, this is our final word. President Trump respectfully submits his reply in further support of his motion to dismiss this case based on the spoliation of evidence and in response to Jack Smith's reply. Now, in a blatant attempt to further Jack Smith's election interference mission by rushing to trial without necessary discovery and fact-finding, Jack's illegitimate office claims that this motion can be summarily denied without a hearing. So Trump's team, as we'll hear, has already said that they destroyed evidence. They manipulated the boxes. They didn't preserve the order. They didn't comport with their own procedures. So we can't vet to see whether they did something that was in alignment with the preservation of evidence. There are standards that we have to make sure evidence doesn't get tainted. But they tell us the failed effort by Jack's team to justify that disposition includes mischaracterizing case law, and they're falsely claiming that there are no indicia of bad faith. So Trump's people are saying Jack Smith not only is doing bad things, but they're doing it in bad faith. They're hiding evidence from us. They're lying about what they're doing. They're not being forthcoming. And attorneys have a duty of candor to each other and to the court. Now, the reason that so few cases address analogous fact patterns is that law enforcement rarely diverges. Okay, so Jack's saying, you don't have any other evidence that supports us dismissing this case based on the spoliation of evidence. And they say, yeah, the reason we don't have other case law is because no one has been so terrible at preserving evidence, okay? No law enforcement ever diverges so markedly from the fundamental obligation to preserve the integrity of the details of the search scene. The search scene is central to the investigation, and what you manipulated was stuff that was favorable to the defense. And so when that happened in this case called Soriano, when they wrecked the crime scene, courts find that that behavior is extremely disturbing and it's worthy of harsh sanctions. And that should be the case here. And so for the reasons that we're going to talk about, Judge Cannon, an evidentiary hearing is required here, followed by a dismissal of the superseding indictment because President Trump has made adequate prima facie showing under this case law that shows that this case must be dismissed. Now, prior to that hearing and any other evidentiary hearing, the court should require Jack Smith's office to make further disclosures regarding the handling of the 15 boxes and the office's ongoing discovery non-compliance. They're not giving us materials. They're not giving us evidence at all, so that the defense is not forced to litigate these issues based on an incomplete and constitutionally deficient record. And so we're going to continue on with this. We've got a whole follow-up to this motion coming on. An evidentiary hearing is required. They're going to blast Jack Smith. But remember that this entire case was started through Merrick Garland, and Merrick Garland is somebody that we talk about and we see and learn a lot about thanks to our friends at Ground News. And now, my friends, we're back with the motion in front of Judge Cannon's courtroom. An evidentiary hearing is required, says Donald Trump's defense team. Says there are no stipulated or undisputed facts about the government's unprecedented, unconstitutional raid at Mar-a-Lago. We are talking about the raid. So we have a big disagreement here. We haven't agreed to any facts. We had any undisputed facts as well. But nevertheless, we can agree on much here. Similar to positions the court rejected in following recent hearings, Jack's office demands that the court accept their description of the raid. So Jack says, just trust us. Deny Trump's motion without a hearing. We don't have to develop these facts. We tell you what happened at the raid. That's good enough. Now, the court has already found with respect to 2 other suppression motions that the strategic prosecution benefits and purported efficiencies that Jack's office prioritizes over Trump's rights cannot carry the day. There's a factual dispute here. Jack says we did something appropriately. Trump's team says we didn't. We have to get to the bottom of this. Now, in addition, Jack's office also lacks credibility, and we can't trust them, so you can't rely on their testimony. The motion that we filed here was precipitated by untimely disclosures from Jack's office himself. There was exculpatory information that they released only after we looked at the boxes. So Trump's team only got news that evidence was tainted and destroyed after they physically looked at the boxes. Dating back to October, Jack's office stonewalled, and they continue to resist valid defense demands for information and evidence regarding and relating to the raid and the resulting spoliation. The office's current Brady disclosures on these issues, which are also incomplete, and Brady's the material that is exonerative material, they only started disclosing those through vague and flippant language in briefs opposing an adjournment that was entirely warranted. And more generally, the office has also made representations and misrepresentations to you, Judge Cannon, including regarding the pertinent facts, and exhibited a generally disrespectful tone that has led to at least 3 admonishments from the court. Judge Cannon is just blasting them in court. Now, notwithstanding all of this, the office apparently believes that they are in the position to demand that the court resolve factual disputes by taking their word for it. We're not going to do that. And so the opposition brief of Jack's office improperly treats the allegations as established facts that have not been established yet. They seek to excuse their failure to preserve exculpatory evidence by claiming without any support that the items in the boxes necessarily shifted around any time that they were moved. Okay, we can't be responsible for moving the boxes. They always move. Things in boxes move. They rely on over 100 pages of exhibits, including private testimonial interviews of these other people. Person 81, person 34, person 29, and FBI 13. Now, some of these witnesses were part of the team, either the filter team or part of the raid team. But these people and these issues were not disclosed to the defense team until May of 2024. It was hidden until that time. Now, Judge Cannon, although Jack's office seeks to portray these issues as straightforward and easily understood, they re-interviewed some of these witnesses a second time in May 2024 because they tried to figure out just how problematic the search was. Why would you need to re-interview people if everything was done appropriately? We have a question about what you did. Oh, you did that? Sounds great. Everything was perfect. Thanks for the information. You move on. If you have to come back and ask them again, just want to clarify. You said this happened. Did you do this? Oh, you didn't. Did you try that? No, I didn't do that either. Okay. Well, they're going to ask about this and this and this and this, so let me ask you. So that is the information the office should have fully understood and disclosed originally. The office's Exhibit 11 is a third interview of FBI Agent 13, and it was conducted after Trump filed the spoliation motion as part of a further attempt to get his or her story straight. So they go back to this person a third time. What'd you do? One more time. So one more time? And maybe they're trying to shove answers in that person's mouth. Are you sure you didn't do this thing? You didn't check that? Are you sure? The exhibits attached to the opposition brief help to illustrate that disputed witnesses' accounts are central to this motion. The defendants are entitled to a vigorous cross-examination of those witnesses because these disclosures have not been made. Now, under these circumstances, they say, Judge Cannon, this is nothing short of irresponsible for Jack's office to urge that no hearing is required based in part on new facts. This is not the first time they've taken that frivolous tack. Now, in addition to ignoring disputes over witnesses, Jack Smith's brief is full of incoherently vague hedging that suggests that they still do not know, this is a good paragraph, or not being forthcoming about at least what happened with the evidence that is central to this case. How did they destroy it? According to the office, the FBI, quote, generally, that's their word, generally replaced, quote, handwritten sheets with classified cover sheets. But they offer no explanation as to what generally even means. Why was that caveat even necessary? Generally, so not always. They also said this in their stupid filing. In many but not all instances, the office claims the FBI could determine which document with classification markings corresponded to a particular placeholder sheet. So sometimes they could match the placeholder sheet with the document, but sometimes they couldn't. Oops. But they have not specifically identified the instances when they couldn't. How come? The office claims that the filter team typically alerted the case team if they identified a classified document, but it's not clear what happened in atypical situations. For boxes in the storage room, the office claims that items order within the box was preserved in the storage room, order was preserved, and contents of the box were preserved, as well as the contents of the box and the circumstances would permit. Now, we do not know for which boxes and what circumstances that is true. Was that true for all boxes? As the circumstances would permit. That might be a typo. As circumstances would permit. But the office argues that it is not relevant, that the FBI was unable to match the placeholder sheets to the documents. You can't match them. They say this problem did not arise for most of the boxes, but not all. Most of them were good. The basic argument seems to be that the court should not worry about this box, A15, because no charged documents came out of it. Well, nothing came from that, so what do you care? But the evidence of mishandling is relevant to the agent's bad faith, and the scope of the problem remains unclear, even by the terms of their own notes. And so finally, some of the factual assertions here by Jack's office are so facially ridiculous and so unsupported by the facts that the office could only have included them in their brief as part of their PR campaign in the media, including unconstitutional efforts. They're now trying to censor even political speech about the raid. They're trying to mitigate the evidence of the FBI's misconduct. Remember when they wrote in their dumb motion? They said, if it was nigh impossible, they said, to keep the boxes intact during the search, then the experienced prosecutors representing Jack's office in proceedings would never have suggested otherwise. The claim is obviously false, okay? Anyone with the patience and inclination to keep an accurate record of the search at the scene, they could have done that. They could have carefully handled the documents. They could have taken notes about the location. They could have relied on an FBI photographer to take actual photos. That same photographer took other staged photos that were leaked. Why didn't they take actual photos of the orientation of the boxes? Now, the decision to take a contrary course and subsequently rely on false claims of impossibility is itself evidence of bad faith. Now, the special counsel's office mischaracterized the legal basis for this motion. They say, trying to avoid a hearing on this, Jack is mischaracterizing this. Trump is not required to establish bad faith to prevail on this. We have established enough. Our motion is based on two separate arguments. First, any objective member of Jack's team could have understood that you need to have an order of the boxes. If classified documents were buried, that's going to change the analysis. Evidence of the location of the documents, whether they're stored beneath other materials, would have been potentially useful for Trump. It would support the arguments that the material has not been seen for years if it was at the bottom of the box, and they're trying to show that Trump has knowledge of the transfer of the materials. But now we don't know, because they pulled all the classified documents to the top, allegedly. Now, Jack's also misapprehends the materiality of this case law. It's disturbing and contrary to the record for Jack's office to claim that the prosecution was not aware of the exculpatory nature of this. That's ridiculous. Although Jack's team has refused to disclose all of the communications with the filter team, there are documents talking about the location of the classified documents, talking about being commingled. And so these statements were included in their instructions because the DOJ fully understood prior to the raid that the locations mattered. The instructions said, note the location. Why? Location matters. Now, against that record, Jack says, well, it's questionable that would even be asked about this. And they bring up materiality, saying it's not even material, but it's unclear. We don't know whether it's material. It's completely unclear about how much evidence the FBI failed to preserve. And so we can't assess this until we have a hearing. A few things are clear at this stage. Photographs of the documents' locations within the boxes could have served as alternative means. They could have taken a picture of the boxes before they started going through them. Did they do that? No. It does not appear that the FBI took pictures of the intact contents of the box. How dumb can you be? They took all those pictures and they didn't even take pictures of the boxes before they went through them. Nor does it appear that cross-examination of the search participants will be a constitutionally adequate alternative. We can't just go ask the people who did the search, as it's far from clear that the FBI agents responsible for the destruction of evidence will even testify accurately about the appearance of even the top-level content of the boxes that they rummaged through. Furthermore, this other case does not require Trump or other defendants to waive the Fifth Amendment right to testify about the composition of the boxes that the FBI should have preserved. And for this cannot be resolved just on the papers. We have no alternative. They destroyed the evidence. We can't go anywhere else. Now, Trump has also made a prima facie showing on its face that the spoliation of evidence was committed in bad faith, okay? They did this intentionally. They lied about it. Prior to the search, a senior DOJ official declared, he said, I don't give a damn about the optics of the raid. And Jay Bratt developed an antagonistic with Trump's lawyer. The defense does not concede the government's request to turn off the CCTV cameras was motivated by safety concerns. Why'd they turn off the cameras? Although the Attorney General, quote, personally approved the raid, the failure to document or preserve the orders of the documents was not consistent with their policies. The office also made misrepresentations to you, Judge Cannon. They failed failed to timely produce evidence related to their notes. They used vague and misleading language in their filings. They proceeded to re-interview some of the problematic witnesses after the spoliation occurred, and collectively, these show clearly that they're acting in bad faith. And so they must make corresponding disclosures for everything now. The court should not tolerate Jack's stubborn refusal to disclose whether the order of the documents is still intact in the 15 boxes that Trump disclosed to NARA. Did they mess those up too? Jack's office takes an all too familiar approach to trying to credit untested claims from another interview, that some of the boxes were consolidated, so they manipulated those boxes. Once again, we are required to call attention to mounting proof that Jack's office thinks that they can restrict their own obligations to disclose Brady material to us. Fundamental fairness requires we get this. The prosecution team alone knows if they maintain the integrity of these boxes. And so at minimum, the office has asymmetric access to the witnesses, and they need to tell us. And now, despite multiple misrepresentations regarding the status of the boxes, Jack's office has said, we take our obligations very seriously, and we've more than satisfied them. But that's not true, Your Honor. Last summer, they told the court that all the discovery was ready from day one, but that's not true. In May of 2024, they gave us more notes from a July meeting that had exculpatory information from FBI agents who conducted the raid. That untimely production was responsive to a discovery demand from us. So Trump's people said, give us more. We want this supplemental. They finally gave it to him, but they rejected that other request at the time. Less than a month later, after they rejected that request, they then said, Your Honor, we've given Trump's defense all of the exculpatory material that we're required to do. Then, in response to a question from the court, the office also suggested, falsely lied to the judge, that the only outstanding material were Agent janks consisting of substantive communications. Turns out that's not true. Now, the special counsel's office claims that the notes were supposed to be on a disk. We just made a mistake. The office makes passing reference to a technical problem, but they don't explain it. This, quote, dog ate our homework assertion is dubious at best, and Trump only got this after requesting this material a second time. They told the court falsely that the entire production exceeded our obligations, and that's obviously not true. Now, just last week, Jack's office suggested that they, quote, don't know the answer to a critical question regarding dissent. Stephen D'Antonio was asked about the raid. He has confirmed to Congress that he dissented from raiding Trump. He raised that dissent via email, but Jack has not turned those emails over. The office's answer at the hearing suggested that they have not even reviewed the communications, which they think is part of the prosecution team. Can we have those emails? Well, we haven't even looked at them. How come? Well, we don't know. It's pure hubris for Jack's office to blithely inform the court of their view that they can just give us discovery whenever they want. Now, it appears that they have not actually completed their case file reviews. They haven't even reviewed all the materials. They can only speculate at this point whether they're in compliance with Brady and Giglio, which requires them to give us evidence. So that is unacceptable. And so the continuing nature of discovery does not excuse their untimely production. They have a continuing duty, and they're producing materials after existing deadlines. Now, the suggestion that they can comply with their discovery obligations is not true. For the office to make that assertion, they're doing it without regard for the Constitution. Now, the office has steadfastly and wrongly refused to acknowledge that Trump is entitled to evidence of political animus. Their current representations cannot prove to anyone that they've conducted the reviews necessary, much less disclose the data to us. In addition to the professed unawareness of discoverable emails from FBI agents themselves, the office only recently produced a handful of August 2022 emails that do not appear to have been included in their case files. Evidence that agents sent substantive messages about the investigation that they failed to upload to the case file necessitates a more thorough review. We gave you everything. Turns out they didn't give him anything. Now, because of Jack's failures to date, the court should no longer accept blanket representations that all of this is under control. This is ridiculous. At this point, there is too much evidence the opposite is true. Based on the discovery deficiencies that are ongoing and repeated assertions that are against not only settled law, but also the Justice Manual, we urge this court, you, Judge Cannon, to require Jack's office to make a detailed submission about the steps that he's taken to collect and produce the discovery, the steps that are ongoing and have not been completed, and when the office will be able to credibly claim compliance with Brady and Giglio, the disclosure cases, with respect to undisputed portions of the team. No evidentiary hearing should take place before these issues are resolved, and the representations will need to be revisited after the scope of the prosecution team is resolved. Signed by a bunch of attorneys we're very familiar with here, Todd Blanche and Christopher Keese, along with Emile Beauvais, Trump's defense attorneys, saying the evidence here was so badly tainted, and the comportment of Jack Smith's team has been so lacking in integrity that you can claim that they're acting in bad faith. They're trying to keep exculpatory material that would exonerate Trump from entering into the defense's purview. And so Trump submits this as a final reply, and now it's going to be off to Judge Cannon to see how she rules and how this goes. We're waiting for some good filings and some good rulings there in Florida. Take a look at this story I found about Attorney General Merrick Garland's whining, calling legitimate criticism against his office attacks on the DOJ. And with all the misinformation out there today, you may have missed this one. I'm looking at this on Ground News, an awesome website and app that combines related news from all over the world and political spectrum into one place. You can check them out by going to ground.news/RGE or just click the link in the description below. Ground News has been an excellent tool for my everyday research when I'm prepping the show, and I think it will be for you too. Let me show you how it works. Here you can see over 10 sources are covering this story, and that more coverage is coming from the left and the center than on the right, which makes sense. We can also see the difference in the headlines, with outlets like CNN repeating Garland's claims while the right calls him out. But not all stories are equal. Using their blind spot feed helps you identify what the media is and isn't covering on either side of the political spectrum, and helps you catch stories that you may be missing. Ground News is amazing because it helps you see what friends and family with opposing views are seeing, and with the upcoming 2024 elections, this will be very important. It's super easy to get set up. Just go to ground.news/RGE or click the link in the video description below. If you sign up through my link, you'll get 40% off the Vantage plan, which is what I use to get unlimited access to all their features. I think Ground News is doing important work, and I hope you'll check them out. Visit ground.news/RGE. Now, an MSNBC lawyer was also out saying that the immunity decision is also very appropriate. So not only is Trump trying to get the Cannon case dismissed on a number of different reasons, this one has to do with the destruction of evidence, but also remember, Cannon has some now potential immunity impact based on Judge Clarence Thomas's concurring opinion. And so here is what this gentleman said in response to questions on MSNBC, explaining why immunity is powerful and appropriate.
So Chuck, I'll start with you. The reaction to this as it came down yesterday ranged somewhere from democracy is dead, we now have kings instead of presidents, to it's a little bit murky. And the murkiness comes in that definition of official acts by a president versus personal acts by a president. Who gets to define that? How you define that? What's your take?
Once again, Willie, I find myself in the rather lonely middle. So I think it is logical that some acts are immune. The core constitutional responsibilities of any president, put Mr. Trump aside, ought to be immune from prosecution.
Makes sense.
Purely private acts ought not be immune. And so the hard part, again, is in the middle, right? What is and what is not an official act? I think we have to avoid the following construction. I don't like Mr. Trump. This opinion is good for Mr. Trump. Therefore, we are on the brink of a constitutional apocalypse. I don't believe that's true. But part of Jack Smith's case is now gone, and he's going to have to fight for the rest. His road to prosecution is longer and bumpier and more narrow. All of those things are true. And I disagree with certain particulars in the case. But in the main, Willie, it makes sense to me that there is immunity in some cases and no immunity in others. And to your point, we have to figure out the rest.
Wow. Okay. MSNBC brought that guy on. Probably the last time he'll ever be on that channel. But that was good analysis. Just set Donald Trump aside, weird freakos. And remember, this is good for you. It's just like an 8-year-old. Eat your broccoli, okay? Eat your vegetables. It's good for you. You're going to grow up big and strong. Many people on the left, you have to tell them, you want immunity for the executive branch, okay? Everybody who's come before us for all 234 years thought and felt the same way because it's a smart thing to have. Now they're running the opposite direction. But Alina Habba is confirming for us this was a good day for America. Here's why.
Of course, it is a good day when the Supreme Court recognizes constitutional rights of presidents and the executive branch, but we should never have been in this situation to start with. This is a disgrace to America. So yes, the lower courts again will have to hear it. It will, in my opinion, slow down Jack Smith's persecution and selective prosecution of President Trump. And I don't see how this case could go forward before the election. But again, I would say that there's still issues to be discussed, such as how Jack Smith even got into this position, how we allowed our democracy, how we allowed the republic to become one that targets political opponents. The fact that we've been in front of the Supreme Court so many times is frankly a sad day for the American people. It's election interference at its finest. But I'm happy today. I think that Chief Justice Roberts made a good decision for what I'm seeing of. Obviously, I need to read it fully, but recognizing Nixon Sessions v. Fitzgerald upholding that decision and stating that absolute immunity does exist for presidents is a good thing. It's an important thing for all Americans, both Democrat and Republican.
Alina Habba in the House, and she is exactly right about this. It is a good day for America to have presidential immunity to put the speed brakes, the speed bumps in front of the Democrats' weaponized political prosecution, enabled by many Republicans who also just sat on their hands while the Supreme Court had to come in and settle all this. But good news, prosecutors destroyed Trump's evidence. Trump's people now making their case to Judge Cannon, and we're excited to see what Judge Cannon finds, not only on the motion to dismiss on that, but also Jack Smith's appointment and where it goes from here. We will continue to cover the Florida case, the rest of the 2024 litigation, and a bunch more here. So we appreciate you joining us as we do. Thank you so much for subscribing wherever it is you're watching this. Thank you for inviting someone you know or love to come over here and join us so that we can go all through this madness together. We, of course, are going to continue our coverage, but coming up next, we have a great video that is talking about Trump's sentencing and how that got delayed in New York. And so check that one out here, and we'll see you back here on the next one.